Hey, good morning, everybody. Welcome back to Law and Legitimacy, where I think it's Wednesday. It's one of those weeks, it seems like it should have ended several days ago, but I guess at or about the time it began. So I think I'm ready for spring break. Whether it ever comes or not, I don't know. Today we will stumble into day 49 of United States of America becomes Gilligan's Island. I was standing at the courtroom door yesterday as court opened, and I decided to hold the door open for folks as they entered. So the prosecution team streamed through, and I said, "Welcome to the Hotel California. You can check in anytime you like." And one of them looked, he says, that line, it's getting a little old. And I said, yeah, so is this trial. Day 49, I was once again in the crosshairs yesterday. And I'm sure it'll become a hate fest for those who make a sport out of deciding that whatever I do is contemptible. It arose during the cross-examination of an FBI agent. She's on the stand, and she had improbably identified individuals from aerial photographs showing maybe 1,000 people in a courtyard, and she'd circle, and this is that one, and this is that one. And so when she did it on direct exam, I took my cell phone out and took a photograph of the video screen, thinking I'm going to have her identify these again when she does it. And if they don't match, I'll have some fun with it. So we get to Exhibit 201, and I ask her, can you identify members associated with the Proud Boys? And she does. And I've got my cell phone up, and I gave the prosecutors a copy of the phone file and whatnot, and they don't quite match. So I show her mine, and I make some sport of it. And one of the government lawyers stands up and says, "What about the rule against photographs in court?" And I said, "I didn't think it applied." So the jury comes out, the judge, "Mr. Pattis, this is unacceptable. There's a rule against taking photographs in the court." And I'm like, I didn't think it applied. I'm ordering you to read the local rules. So I did. And the local rule says there shall be no photographs or recordings in court, and broadcasters shall not air live. So I looked at that rule. When I initially read it, I thought it referred to what reporters are doing in court. You can't broadcast live, you can't record and then rebroadcast. Didn't say lawyers can't do it. So I point that up to the judge, and I said, look, that's how I read it. I see how you see it. We'll see what happens. So never a dull moment. If I didn't create a little bit of controversy, I wouldn't know why we're alive. So all of which to say, I'm expecting to be invited to speak, at the Stanford Law School any day now. I'd like to give the follow-up talk from Fifth Circuit Appellate Judge Stuart Kyle Duncan. Mike, what up at Stanford?
Man.
And did you dare call it the Stanford Law Stool?
I did. The title of this video is Stanford Law Stool, but it's not without reason, because Judge Duncan did refer to what happened at Stanford Law School as dog shit. So, I'm just being me. But if we can just briefly recap the facts for our viewers, because I do think that we're going to get way in the weeds on this. This is at its essence of free speech versus heckler's veto versus, I guess, American educational institutions and their purview. So Judge Duncan, Fifth Circuit judge, appellate judge, he was invited to speak at an event that the Stanford Federalist Society was hosting.
And for those of you who are new to all this, the Federalist Society is generally regarded as a conservative group of people devoted to an originalist interpretation of the Constitution. I say this because about 15, 20 years ago, I was invited to speak at the Federalist Society at some college, and I didn't really know what the Federalist Society was, even though I'm a lawyer. I just hadn't paid any attention to all that stuff. And I got in there and I thought, boy, these people are pretty conservative.
Yeah, well, and I think on the Stanford Federalist Society page, they say that they're a group of libertarians and conservatives interested in the current state of the legal order. The Federalist Society promotes the principles that the state exists to preserve freedom, that the separation of powers is central to our constitutional order, and that it is the province of the judiciary to say what the law is, not what it should be, which I think is a pretty reasonable mandate there in credo. But what I've got on the screen here, you see Judge Duncan there. And this is a video that was circulating the internet late last week, and it's about 9 minutes long, so I'm not going to provide the audio, but I just wanted to give people a view into what we're talking about. And this video comes courtesy of Jack Posobiec, who reposted it. You can see there. I love this. Keep doing it. Colleges do it every time someone comes to campus. Accelerate. I think that what what Posobiec is saying there, that, the best, sunlight is sort of the best disinfectant kind of thing. But who you see right there, the female that is standing at the podium with a prepared speech, that is the diversity, equity, and inclusion dean, Tyrion Steinbeck, I believe. And, Judge Duncan arrives there. I still don't necessarily know what he was there to discuss, but there were at least, I think 100 people that I've read that were there to what they call counter protests. So they were shouting him down, making it nearly impossible for him to even begin making his remarks. He requested that an administrator come in and quell the hecklers. And so this is the administrator that he got.
My understanding is that the event was billed as, COVID, I think abortion or something or other, the Fifth Circuit in dialogue with the Supreme Court. So in other words, it was going to be a discussion about constitutional issues that have arisen in response, presumably to the Roe decision, Dobbs overturning Roe, and the response of the states and litigants generally, and the emergence of the public health state and the Fifth Circuit's decision on these. And, whatever cases were hot in the Fifth Circuit as relates to individual liberty, federalism, and or the structure of government, and what it was like to be a judge one step removed from the United States Supreme Court, and what issues were likely to emerge in these hot topics in courts in years to come. But that the judge had, in a decision not long ago, apparently refused to use a litigant's pronoun of choice. And so people began to prepare. Oh, and so the event gets broadcast on campus. People have something to say about it. Members of the Federalist Society go to eat in a lunchroom that is normally used by LBGTQ plus. I'm not even sure what initials you're supposed to put in there. The ABC crew, and frictions began to arise. And so that as he entered the room where the Federalist Society was going to host his talk, there were a lot of people there with posters, and a lot of people began to shout him down even as he began to speak.
That's right. Well, and before we go further, I want to take a moment to acknowledge High Society's question. He says, what does that mean when you attach the word circuit to a judge? And then he puts in quotes, Fifth Circuit judge. Norm, do you want to take this?
Sure. So the federal courts, there are two levels of court system in the United States. There is a state system, and each of the 50 states has their own independent judiciary organized as a matter of state law. There is also a federal judicial system that oversees the entire United States. So the concept of federalism means that we have both a federal government with national jurisdiction and reach and power over every 50 states, and we have independent state governments that have sovereignty and independence within themselves. In other words, the federal government can oversee what they do, but there are whole areas of life within the states that are up to the states to decide how to manage. And that's the genius of federalism. The federal courts are organized in the following way. Almost without exception, cases begin in the district court, that is a trial level court. There are 94 judicial districts in the United States. Some states like Connecticut or Vermont are so small, they have but one district in them. New York has an Eastern District, a Southern District, a Western District, a Northern District. So these are all trial level courts where people come to have their disputes heard. If you want to take an appeal, if you're unsatisfied with what happened at the district court, you go to a federal appellate court, and those are denominated circuit courts of appeals. Thus, the Second Circuit Court of Appeals is the federal appellate court with jurisdiction over the federal courts located in Connecticut, New York, and Vermont. The Fifth Circuit is in the central part of the country, and candidly, I don't remember the states or the jurisdictions that report to it.
North Carolina would be the Fourth Circuit, et cetera. California, I believe, is the ninth part of the Ninth Circuit. So whenever you hear High Society, whenever you hear a reference to a particular circuit, think geographic area over which an appellate level judiciary hears cases and controversies appealed pursuant to federal law.
And then from the 11 circuits, at the apex of the federal judicial system is the United States Supreme Court, and there are 9 justices. So a justice sits on the Supreme Court Everyone else is a judge. And so you've got judges of the Fifth Circuit, Second Circuit, Third and Fourth, and then you've got district court judges or trial judges, and that's all that mumbo jumbo means.
And one good question that he follows up with: are those judges appointed, or are they leveled up over time and experience? If that makes sense.
Yeah, they're appointed. All federal judges are appointed and go directly to their job. So the way that typically works is they're appointed they're nominated by the president, and then they have to be approved by the Senate, and then they're confirmed by the Senate if the Senate wants to confirm them. There aren't really job requirements for this. The Senate, the president of the United States could nominate Alexandria Cortez or Ocasio-Cortez, even though she is not a lawyer, to be a judge. She would be unlikely to be approved, nominated, and confirmed. So typically, there is a vetting process, and you have to be competent in general, to get one of these jobs. The people who become judges usually want to become judges. They're ambitious. They cultivate relationships with people in local bar associations or law schools. And in Connecticut, for example, there's a committee that is informally called by the two senators in the state, and they vet nominees. And then once the two senators agree, that they'll recommend that this person be appointed by the president, and the president can select from among those recommendations. So it's a complicated process. It's a very political process. There's an opening on the United States District Court trial bench in Connecticut that's been open for well over a year. One person was the preferred nominee. They were vetted and investigated by the FBI, their name kicked around. Apparently that nomination has fallen apart, and just recently, within the last week or so, another nominee has been appointed, and that process has begun all over again. All this before the nomination even surfaces before the public. So it's you may think that this is just somebody sitting at home. Oh, hi, Joe Biden. So glad you called. Yeah, sure, I'd like to be a judge. Yeah, I'll show up for my confirmation hearing next week. So happy you called. Thanks. You say hi to Dr. Jill for me. Click. No, it just doesn't work that way. These are people who are very ambitious and who want the jobs badly.
Yeah, and so he says, I appreciate you stopping the class for little old me. So you're welcome. And of course, in the cloud says, hi, society. I appreciate your questions. Helps those of us who aren't from a legal background. And I think that's the idea. The point with the circuit reference is to know that unless there is a state level controversy that exceeds certain dollar limits or something called diversity jurisdiction, largely the federal circuits are interpreting issues of federal law, right?
Yeah.
By and large. And just to follow through a little bit, if you try to take an appeal from a circuit appellate court, you are doing what is known as petitioning the Supreme Court by way of writ of certiorari to hear your case. So the next level of scrutiny, if you are to appeal past the federal appellate circuit level, would be to the Supreme Court.
And you take a whole class in law school on jurisdiction, and so these are difficult questions that
I had to throw this on the screen. Justin says Ortiz, Cortez, whatever.
Yeah, well, I can't remember her name. Every time I think of that particular congresswoman, I just think of a donkey, because I see those big teeth and that big smile of hers, and I'm realizing if I'd walked into her Starbucks for a coffee, I'd probably want a rabies shot first. But we digress. Let's go back to to Judge Duncan and Dean Steinbach and company. So he wants to talk about his perspective on the law. And he's been invited by the conservative. He's a conservative jurist. Many of the students there were opposed to what they knew of the judge, his rulings, his decisions. They regard him, he had opposed apparently gay marriage at some point. He'd refused to use pronouns of choice. So clearly he is a judge who, by temperament and by his decisions, had placed him outside the so-called woke agenda. And so the students come to the lecture intending to be heard. And so the question is, what happened at this meeting? Now, there's an interesting piece in Above the Law this morning that basically criticizes Duncan. And I read the piece with interest because Mike challenged me yesterday. He said, where's the protein in your diet? You're selecting all this stuff that comes from a certain perspective. And I'm thinking, yeah, I am in my silo. And one of the points of this podcast is to stretch everybody some. So I read the law, above the law piece, and basically they said that Duncan blew an opportunity. That when the students expressed hostility, he could have responded with something other than hostility or irritation himself. He could have found a way to engage them on their own terms. And I suppose that's true, but I think that above the law missed the larger point. I think that the Federalist Society was an organization that has a political point of view that is largely conservative and is concerned with the institutional role of courts, with a limited role, a view of a limited role of government. And they invited a conservative jurist to talk about his view of developments in the law from within the confines of that perspective. Those who don't like that perspective came to the meeting looking for trouble, and they found it, and they disrupted the speech. Now, should he have thrown aside his prepared remarks and said, well, let's reason together about the issues that brought you here to my forum? One could argue he could have, but wouldn't that be giving the heckler his way? Wouldn't that be saying to the 2-year-old?
He's here on behalf of the Federalist Society, the Stanford chapter of the Federalist Society. This isn't something that he's there to represent their interests. He has come and committed to prepare remarks on those specific issues. My problem is that these are law school students and these are kids, and if kids act unruly, this is a question of almost parenting in a way. But before we get too far ahead of ourselves, because like I said, there's been a lot of events unfolding over the last, I would say, 96 hours on this. This stuff was ripe as of, I think, March 6th. So we're kind of recapping a lot of this stuff in real time. I want to read for you, Norm, the prepared remarks of the dean, the diversity, equity, and inclusion dean, Steinbeck, that you saw there. I guess like the bigger hair, talking after Judge Duncan asked for an administrative.
Okay, but here's a teaching moment, because I'm like these kids in the classroom. I don't want to hear from a DEI dean at a law school. I mean, she's got about as much a role in legal education, as far as I'm concerned, as does the janitor in preparation of a souffle. However, I'm not going to engage in a heckler's veto. Let's hear what she had to say.
So her quote when she stood up there, this is one of the more meaningful quotes. She says, quote, "I'm also uncomfortable because it is my job to say, you are invited into this space. You are absolutely welcome in this space where people learn and, again, live. I really do wholeheartedly welcome you." And she's referring to Judge Duncan, because me and many people in this administration do absolutely believe in free speech. We believe that it is necessary. We believe that the way to address speech that feels abhorrent, that feels harmful, that literally denies the humanity of people, that one way to do that is with more speech and not less, and not to shut you down or censor you or censor the student group that invited you here. That is hard, that is uncomfortable, and that is a policy and a principle that I think is worthy of defending, even in this time. And again, I still ask, is the juice worth the squeeze? To which Duncan replies, "What does that mean?" I was
thinking that myself. I was thinking, do they not teach writing any longer at Stanford? Do they not expect their administrators to be able to express themselves in clear declarative statements? I think what the dean was trying to say is, well, we value speech, but your speech hurts, and because it hurts, we have to balance the harm that your speech is causing against your right to utter it. And she could have said that in a whole lot fewer words. But I think the letter does illustrate an interesting debate. I mean, I see those on the left who say that free speech is not an absolute. That sometimes ideas and ideals are so abhorrent that they need to be opposed if necessary, with silence and with force to silence them, because some utterances are too harmful and denying the humanity of another. Now I'm not sure that deciding you're not going to use a person's pronouns is denying their humanity. That seems like a 9-alarm fire in response to a matchstick call.
But it was also a 2020 opinion, and the case was actually about someone convicted of possession of child pornography who was seeking to transition and his refusal in court to honor preferred pronouns. And so that was, I think, a small sideshow that blew up in a major way, that sort of instigated what I think was already a predisposition to oppose anybody with conservative viewpoints at Stanford Law School. I don't think that that's anybody who is sort of, in the middle on this issue can see that that was not anything for them to blow up over and suppress speech about. If so, if there was genuine curiosity, I would think that people who see the world through a different set of lens could have sat there and asked a question.
So what should Judge Duncan have done when he walked into that room filled with hecklers, hostility placards, and those intent on disrupting his speech? What should he have done?
Well, my opinion from watching the video, and again, that's only 9 minutes of what was a much longer ordeal, there wasn't a whole lot from my perception that could be done. I mean, the hecklers were there screaming obscenities, and forgive me, YouTube and Rumble, if this is against your policy, but, they're saying things like, why can't you find the clit, and things like that. I mean, we're not dealing with hecklers who are shouting substantive things that should make him think. This isn't a situation where anybody was making it clear that they were there to engage in some sort of, good, hard, substantive debate. It was more about absolutely shutting him down. So maybe I pushed the question back to you. I'm not sure that I would have known what to do other than what he did, which was, this seems clear that in these situations, the administration is responsible for removing people who are disrupting scheduled events on school campuses. But that's not what happened. So Norm, and I think Justin asked, what would Attorney Pattis have done?
Yeah. So, if that had happened to me, I probably would have started by, you would prepare remarks. You'd never try to go and ask to speak, to read something that you've written. You want to interact with the crowd, but you have an outline. So I would have started down my outline, and they would have heckled. I would have ignored them for a while. If they made it impossible to proceed, I would have asked them for permission to proceed. If they had then said, well, we'll do so, but only if you address X, Y, and Z, I'd say, can you please save that for the comments section? If they refused at that point, I don't think I would have called for the administration's assistance. That was a move. That's a move that wouldn't have occurred to me. I would have either tried to continue. I would have asked my hosts, can you deal with this? I didn't expect to deal with this. And then I probably would have walked out at some point. But Duncan did something that was surprising. He asked for an administrator to come in, at least surprising to me. And the administrator came in and failed to strike the right balance. And so I think his talk ended abruptly. Stanford ended up apologizing to the dean. Do you think that?
So I've got this apology on the screen, and I think the one thing that they don't pledge to do here is indulge any accountability for the students that were responsible for what was going on. But I'll read a little bit here for those who are listening only on Spotify or Apple Podcasts, Google Play, etc. after the fact. This is from the dean of Stanford Law School, Jenny Martinez, together with the president and being presidential professor Mark Tessier-Levine. They say, "Dear Judge Duncan, we write to apologize for the disruption of your recent speech at Stanford Law School. As has already been communicated to our community, what happened was inconsistent with our policies on free speech, and we are very sorry about the experience you had while visiting our campus. We are very clear with our students that, given our commitment to free expression, if there are speakers they disagree with, they are welcome to exercise their right to protest, but not to disrupt the proceedings. Our disruption policy states that students are not allowed to, quote, prevent the effective carrying out, quote, of a, quote, public event, whether by heckling or other forms of interruption. In addition, staff members who should have enforced university policies failed to do so and instead intervened in inappropriate ways that are not aligned with the university's commitment to free speech. We are taking steps to ensure that something like this does not happen again. Freedom of speech is a bedrock principle for the law, the university, and a democratic society, and we can and must do better to ensure that it continues even in polarized times. With our sincerest apologies again," and they sign their names. I don't know what your initial impressions are, Norm, but I'll go ahead and share that I don't give Stanford Law at this point, or really any Ivy League institution in this day and age, I don't give them the benefit of saying that that free speech is one of their bedrock principles. They seem to sort of take it for granted. That what do they say? given our commitment to free expression. I don't treat that as a given right now.
Yeah, I think they missed a teaching moment, because
Yep.
I think that, while even when the state has even though we have freedom of speech, what bedrock principle of First Amendment law is that the state can impose reasonable time, place, and manner restrictions on free speech. Thus, you don't want somebody screaming outside your bedroom window at 4 o'clock in the morning, "No war in Ukraine!" They're entitled to their opinion, but how they express it and when matters. And in a law school, where students are presumably being educated to represent others in life and death conflicts, appreciation of decorum rules should matter, and learning about time, place, and manner restrictions, and learning how to stifle your own rage, and how to hear the views of another in an orderly fashion should be part of the education. So if I were in the law school, well, of course, I'm about as likely to teach in the law as I am to become a federal judge. But, if I were part of that university, I would want Steinbeck shown the door. I think that when she came in and she tried to lecture Judge Duncan on his sensitivity and his need to coddle the hecklers, I think she showed herself to be a sort of advocate, rather than an administrator. And she failed to help Stanford meet the mission of a liberal arts institution, which is to educate and foster a diversity of points of view and norms of civility that permit people, even with diametrically opposed views of life, to occupy the same space and reason together. She should have said to the students that were heckling, hollering, screaming, and carrying on, "Sit down, shut up, sign a list, and you'll speak. You'll have a chance to speak when spoken to." Instead, she adopted basically a far left attitude towards speech, and it is that attitude which is seeking to, in my view, come up with litigation strategies to make it impossible to utter what is hate speech. And of course, this begs the larger question, which is, who gets to decide what is and isn't hateful? In a democratic society, we leave that to the metaphor of the marketplace of ideas, and we trust the people, an educated public, to work things out on their own by being exposed to a diversity of points of view.
Yeah.
There is an emerging tendency to believe that some speech is so harmful it cannot be uttered, and therefore it ought to be stifled. And Stanford seems to endorse that view while giving lip service to the liberal ideals of free speech. It has in fact endorsed the behavior of Dean Steinbeck and what I will refer to as the PC thugs who disrupted Judge Duncan's speech.
Yeah, well, and again, I just think it's sort of a clown show when you think about what she actually, the remarks that she prepared, because she was there reading from that and trying to sort of perform it to him as if it were off the cuff and say, "I didn't have remarks prepared." But look, she said, in part, "We believe that the way to address speech that feels abhorrent, that feels harmful, that literally denies the humanity of people, ... Right. And again, that just, you're not being an administrator. You're not being an arbiter of campus and school policy. Right. You're taking a side, and you're trying to veil that by appealing to some sort of empathy or sympathy.
But here's where it gets interesting, because I am noticing this more and more. I mean, we can say that all points of view should be respected. But suppose, and I don't think that Duncan denied anybody's humanity. That's histrionic nonsense. But what if they had invited, a young Hitler, who wanted to talk about the need to engage in social eugenics against, to sterilize the wombs of women, all women who had IQs of less than 90, because in the 3 generations of idiots is enough to rehearse the line from Buck v. Bell, which some people are quick to point out has never been overturned, even though it's been ignored and repudiated. What is there a line below which the commitment to free speech ought not to go? And and I think we all would agree that there is. But the problem with making an agreement to that commitment places us in the censor's position. And I think from the perspective of Dean Steinbeck and others like her, they're trying to raise the bar on what constitutes civil discussion, and our criticisms of them miss the point. How would you respond to that, Mike?
Well, we're not even talking about the substance of Judge Duncan's remarks. That's the problem. And,
Right.
and part of the issue here is that the Overton window has shifted so much. And one thing I wanted to point out here, because T-Girl, you kind of predicted where I was going in the chat. You said now they're going after the dean for apologizing. And I've got Aaron Siberium's reporting here on the screen for, I believe, what is this? This is the Washington Free Beacon. And he's got a companion story to this that actually covers the quote unquote dog shit remark that Judge Duncan used to describe sort of what the students are doing there. But I think that I want to fast forward to say, because we're running over time here, Judge Duncan is absolutely correct. What I step back and think is, if there are more than 70 students sending emails to faculty or to this student-led organization on a law school campus, law school class sizes are not that big, Norm.
Right. That's
So
true.
I must question the admissions protocol for students that are led this strongly in a single direction and have likely not even completed their First Amendment doctrinal courses, or if they have, they're not being asked questions that lead them into this substantive debate, that acknowledge anything about the notion of free speech and the importance of free speech as basically the cartilage between our bonds in civil society. And that troubles me. But what Judge Duncan would say, Norm, is that, and what he has said, is that the most terrifying aspect of all of this is that the students from Stanford, the students from Yale, those students that are doing this are the ones that are going to matriculate into the law. And he is worried
that
at the point that they do matriculate into the law, that the state of law in America is going to be an absolute shambles. That's what the reference to dog shit is. And so from that perspective, I think that the Stanford administration has a massive responsibility and obligation to get this under control, because it's not so much that the students were led to do that. Now, I will put an asterisk by that, because I just said audit the admissions protocol. Why are so many students coming in here? And there's data from Jonathan Turley. He'll talk about the lack of diversity of opinion and thought and political sides on all college campuses right now, particularly in law schools. But why is it such that a dean can walk in there and make a situation worse?
Well, that's a great point.
Right.
And we'll have to kick this can down the road because we're out of time. I got to get ready to head over to court. And we should pick up with this tomorrow. I'm trying hard to push back against my instinct, which is to simply condemn the dean and understand, what the students were trying to say and what they did and what it represents. But you raise a good point, Mike. If these are going to be the future leaders of the law, then I think our society is in great trouble, because many of these folks will go on to become judges, and they will be given the power to decide disputes. And if their way of deciding disputes is by silencing the opinions they disagree with, then the First Amendment is indeed at risk.
That's absolutely right. I'd love to keep talking about this. There's much more to dive in on this topic with, especially the notion of free speech versus the heckler's vetoes. There's real case law and precedent from UC Berkeley and other things that would give us a context to debate what a heckler's veto is and is not, more importantly. But for that, we'll have to delay to another day. I'll let you get to court. I'm going to go ahead and overrule the objection that you would make, just to say that please put a thumbs up on this video. We had a lot of live viewers today. We appreciate that. Please give us a thumbs up, like the stream, subscribe to the channel. You can find us on Apple Podcasts, Spotify, Google Play, Audible, etc. And follow us on Twitter at Pattis Podcast. We went live on Twitter this morning, so if you forget, follow us, turn the notifications on, and then you'll make sure that you won't miss it. Norm, I'll let you get to court and do the Lord's work.
Is that what I'm doing? I'm just objecting and fighting, because that's all I know how to do. I'll see you tomorrow. Thanks for everybody for sharing your time with us.
See you later.
Can I bust on these amateurs, paint my business off stage?